Hi, my name is Daniel Tekanoff. I'm an attorney and self-published author in Fresno County, California, and today I'm going to present to you how to think critically about the U.S. Constitution. We'll focus on amending the U.S. Constitution through the peaceful Article 5 Convention of the People. This is my book, Guide to the First Article 5 Convention of the People, The Constitutional Path to Taking Our Country Back, now available at Amazon.com. We begin the lesson by thinking about the textual provisions in the U.S. Constitution. They can be per the theory of free government, or they can be compromises of that theory. The more that constitutional provisions are per compromise, or are per theory, but have been shown by experience to be defective, the more the rule of law is threatened. Some routine constitutional maintenance by the Article 5 Convention is necessary. We learned the original theory of free government by studying the original history of the Constitutional Convention and the gap period in between the Constitution's preparation and the preparation of the Bill of Rights 2 years later in the first Congress. So we're going to look at the Constitutional Convention here so you understand how this theory of free government came together and how there are still some things left for us to do. The Constitutional Convention basically took place in two sessions. The first session was May 25 through July 25, 1787. Then the Committee of Detail took over to prepare a rough draft of a constitution. And then a second session took place from about August 7 to September 17, 1787. Right at the end of that, a Committee of Style and Arrangement met from September 8 to 12 of 1787 and wrote what was near the final draft of the U.S. Constitution. Then 3 more days of work on September 13, 14, and 15, another clause-by-clause review, and then finally the signing of the Constitution on September 17, 1787. So just before the elections for the Committee of Detail, Oliver Ellsworth, a delegate from Connecticut, ends up getting elected to that Committee of Detail right after he makes this comment that reflects directly upon what our theory of free government is, that since the Articles of Confederation, a new idea had crept in, as he says. Conventions of the people, with power derived expressly from the people, were not then thought of. That same date, Gouverneur Morris sets forth an idea that causes some of the other delegates probably to start thinking. He moves that the ratification should be a general national convention chosen and authorized directly by the people. That was rejected. Instead, the delegate body went with state ratification conventions, which would be chosen directly by the people. Now we advance in time a little bit more than a month. We have just about 2.5, 3 weeks left to go in the Constitutional Convention. Edmund Randolph gets up and states that there are features so odious in the Constitution as it now stands, he doubted whether he should be able to agree to it. He's basically giving a warning to everybody that he thinks that there's just been too much compromise of theory, that they need to work harder, or he's not going to support this form of the Constitution. Then just a couple days later, on August 31, 1787, you see sort of a coalition of caring statesmen is the way I would put it, basically saying, we don't like the way this is going. So Colonel Mason, George Mason, seconds a motion by Elbridge Gerry to postpone the discussion of the ratification clause. And he wants some major revisions on how that's going to get handled. And he declares that he'd sooner chop off his right hand than put it to the Constitution as it now stands. He's saying he wants some things changed, and if not, he wants to bring the whole subject before another general convention, which means elected directly by the people so that they could give their true voice as to whether to consent to these changes in the Constitution. This same day, you see two others speaking up in favor of holding a second convention. Gouverneur Morris speaks up. He was in favor of another convention. He wanted to see more vigor in the government. His idea, I believe, was that if the people have a say in the formation of the new government, they're more likely to respect the law. Edmund Randolph gets up once again. He says the state conventions should be at liberty to propose amendments and that another general convention should be convened afterwards to discuss all of this once again. Advancing in time another 10 days or so, this is Monday of the last work week of the Constitutional Convention. And Edmund Randolph again stands up. He reminds everybody he was the one who brought forward the set of Republican principles at the beginning of the convention, that basically the theory of free government had been compromised so much that he did not feel like he could support the current form of the Constitution. And he was calling for state conventions to have an opportunity to offer amendments, and after that, for a second general convention to be called. So Randolph actually makes a motion that day to make sure that the state conventions would have the power to propose some amendments, and that the entire ratification process would close with another general convention, meaning of the entire nation, with full power again to make some alterations, both by including adopting the ones that the state conventions propose, and I would expect to make further once delegates came together and they had further time to deliberate. And so that actually was seconded by Benjamin Franklin, very interestingly. So it's the Wednesday of the last work week, September 12th, and they're realizing that there's no Bill of Rights. George Mason and Elbridge Gerry move for a Bill of Rights. It gets rejected. Now we're going to Saturday, September 15th. It's the last work day, and we're at the very end of the convention. And so the delegates who are objecting and refusing to sign are making their final statements. And here's Edmund Randolph. He's saying, I'm making a motion that amendments to the plan might be offered by the state conventions, which should be submitted to and finally decided on by another general convention. And so it's the same issue he's been bringing up now. This is at least the third time. George Mason seconds the motion of Randolph. He's saying, look, this Constitution has been formed and the people haven't even had a chance to give a comment on it. A second convention would know the sense of the people. And keep this in mind, what he's saying here on September 15th, because just about 3 weeks later, he's going to send a letter to George Washington explaining what he means by a second convention. And he's basically saying it's improper to say to the people, take this or nothing. They should have a chance to propose amendments in a second convention. And so with the expedient of that, I'll sign. Elbridge Gerry also stated his objections and then also added his support for going to a second general convention. That was rejected, and that was basically the end of the Constitutional Convention. Here's the letter from George Mason to George Washington 3 weeks after the end of the Constitutional Convention. He's providing Washington with a copy of his objections, and he's referring to basically how there was too much impatience at the end of the convention. And if people weren't so impatient, maybe some of these problems could have been removed. And he's basically stating the theory of free government very clearly here to Washington, that this should be submitted to a convention chosen by the people for the special purpose of constitutional amendment. And what happens after this point is Washington and Madison and Jefferson and others go into action to cut off a second convention. They never deny the correctness, that the Article 5 convention is a constitutional convention which would be chosen by the people directly for the special purpose of constitutional amendment. In fact, the reason they go into action because that's what they know it is. And they want to cut that off because they just spent all of this time. And by going through another process like that, it could upend everything. And so the strategy was to convince people to accept the Constitution as written, subject to preparing a Bill of Rights in the first Congress that would only mostly deal with protecting individual rights, and then anything dealing with the check and balance structure, they wanted to reserve that for time and experience to show us where those defects are. So this is advancing into the future about 2 years. The state ratification conventions have met, and enough of them have ratified the new Constitution that the new government is going to begin. George Washington is elected president, and he gives his first inaugural address, which is actually written by James Madison. And in here, he's asking the nation to avoid alterations which ought to avoid the future lessons of experience. And he's referring to structural amendments. Here's James Madison near the beginning of the first Congress when he's explaining his motion to begin preparation of a Bill of Rights. He's explaining that he doesn't want to alter the main structure or principles or cause it any injury. He's referring to the check and balance structure and the principles of the separation of powers. He said his object was to quiet the mind of the people by giving them some assurance that their rights will be expressly provided for, meaning a Bill of Rights protecting individual rights. He also wanted to make sure there was something in the Constitution that expressly stated that the powers of the federal government were limited. And in the end, there were 2 other amendments. One, which was to limit Congress giving itself raises until after a subsequent election, which is now the 27th Amendment, and then a ratio of representation guarantee. And that amendment never got passed, and that is what is facing us now as a problem, both in the legislating system and the amending system. So in summary, the framers cut off a second convention, which would actually be the first convention of the people at the national level. They cut that off by preparing the Bill of Rights in the first Congress, so they met that part of their promise, and they did get that done. The second part of the promise, that we would go back into a second convention, which is actually the first convention of the people at the national level, to address structural defects, when those are uncovered by time and experience. And we've uncovered some of those defects by time and experience, but we still have not yet gone into the second convention. And so that is the focus of where we are at now. After familiarizing ourselves with the original constitutional history and the original theory of free government, what is the key to opening the door to the U.S. Constitutional Convention? Per original history and theory, we would look at 3 factors on when to call for the first Article 5 convention, which would be 1, when Congress becomes corrupt. George Mason's statements on June 11 and September 15 at the convention about that. A second reason that comes up is if Congress won't propose necessary amendments. Federalist 49 advises us we have to keep this constitutional road open. A third reason are defects discovered through experience. We've discovered several deep structural defects through experience, including a failure to complete the Constitutional Convention Clause itself, a failure to complete the Bill of Rights with a ratio of representation guarantee. And now we're looking at things like the Elections Clause. Maybe that needs to be housed inside the Constitution itself so that neither the state legislatures or the national government can make mischief with the election system. And another possibility now that we're seeing, maybe we want some kind of constitutional rule regarding how much power the government has during time of pandemic. I'm going to read through the Article 5 Constitutional Convention clause, and as I do, ask yourself, who gets to go? How many delegates from each state get to go? Who is electing them and who is making the rules, the suffrage rules? Here's the clause. The Congress, on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which shall be valid to all intents and purposes as part of this Constitution, when ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by Congress. Some will ask, why didn't Madison say anything? Why didn't Madison warn us? Probably to protect the extension of the sphere of representation, which he teaches us about in Federalist Number 10. He wants to protect whatever generation is calling for the convention. He wants to protect their power to decide what the ratio of representation will be. And so he decided not to say anything. Because if he did, then somebody in his age would probably say, well, let's fix this, and they would choose a rule that would then be imposed upon us potentially 10 or even more generations later. So be aware, if we're making a call for a constitutional convention per Article 5, all Americans have a claim to have a right to be at that convention, at least at the first meeting, per the 14th Amendment Equal Protection Clause, because there is no elections clause in Article 5. There is an elections clause in Article 1, so you can make the clear argument, easy argument, the framers must have known what they were doing. They chose not to put the elections clause in Article 5, knowing that that meant that everybody had a right, an equal right to be there until rules for who got to go are chosen in the current period when people want to go to convention. The defect in the Article 5 Constitutional Convention Clause was clearly discovered by the 1960s. That's when the court issued its ruling in 1962 in the Baker versus Carr case that overruled older cases that talked about certain areas of the law being political questions. The court overruled those old cases and now made all new cases a case-by-case analysis, and that included old case law regarding the Article 5, or not regarding the Article 5 Convention, but regarding Article 5 Amendment generally, as well as old cases regarding malapportionment. Baker versus Carr opened up the way to overrule an older case called Coldgrove versus Green. In 1964, the Supreme Court starts finding some legislative apportionment unconstitutional. Reynolds versus Sims, dealing with Alabama. Lucas versus 44th General Assembly, dealing with Colorado. And then the case of Westbury versus Sanders, which set a very clear rule for the U.S. House districts as well. Now, throughout the nation, you had a one-person, one-vote rule pursuant to the Equal Protection Clause of the 14th Amendment. The only the only exception is in the Constitution itself for the U.S. Senate or, for example, the Electoral College. The one-person, one-vote cases required all state senates now to be based upon a one-person, one-vote election. And so that caused a really big reaction in the states. They saw their power being taken away, and so they started calling for the Article 5 Convention, but only for one specific type of amendment, to allow apportionment of one chamber of their state legislature to be based on something other than population. And as they got really close, they got to 33 states, they started pulling back because they realized that the drafting issues in Article 5, they weren't sure what was going to happen, but they realized the possibility was that they were going to open up a clause-by-clause review. And while they didn't state it in that exact language, that fear caused them to pull back. Literally within a decade of the last push for an Article 5 convention, another push for a balanced budget amendment is made, but through the Article 5 convention process rather than through Congress. 32 state legislatures vote for it. They realize again, we might open up the Constitution to what they call a runaway convention, and that causes them to retract their applications. Though in reality, there is no such thing as a runaway convention, because the convention has full power. It has plenary power. And so when they vote for the convention, they should be voting for the full convention, a full-powered convention. Runaway would be going against voters' wishes, not going against the state legislature's wishes. Congressional reaction to the attempts to call for the first Article 5 convention was to start proposing some Constitutional Convention Procedures Acts. None of them were ever passed. What we learned, though, is that Congress was incompetent. They did not understand the theory of free government. What they should have been doing is teaching the state legislatures that they should be calling for a general convention with full power to do a clause-by-clause review, not trying to assert power over the national system. The power to write an elections clause for the Article 5 convention is reserved to the people via the 10th Amendment. The 10th Amendment states, the power is not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Every word must have meaning. The word respectively means each as to each. So the 10th Amendment basically means that states retain all power that they held prior to the Constitution going into effect, but only as to their own laws, not as to the laws of the nation. Here's a basic illustration of the problem. If Congress will not act, there's only one other way to get a constitutional amendment, and that is to start an Article 5 convention. But you can't start the Article 5 convention until you set up the rules and procedures, including the suffrage rules. Who will be a delegate? What is the ratio of representation? How many delegates from each state, etc. Well, the only people who have the power to do this are the people sitting in convention, and so you can't start that convention without those rules. And so you have a feedback loop. I call it the devil's loop of the American Constitution. Two modern Supreme Court cases helped clear the way for the Article 5 Convention of the People. I call them term limits Roman numeral 1 and term limits Roman numeral 2. The first case is U.S. Term Limits, Inc. versus Thornton, a 1995 case, which implicates the 14th Amendment Privilege or Immunities Clause. It makes very clear that in the American system, sovereignty is vested in the people themselves, and that means that the people choose freely their own representatives to the national government. It's considered so essential for all other rights, it ought to be considered as one of the most sacred parts of our Constitution. This seems clearly to telegraph to the people that if the people want to call a constitutional convention, the court's going to back us up and make sure that we're able to elect our own representatives to that constitutional convention. As the court stated, the states can exercise no powers which exclusively spring out of the existence of the national government, which the Constitution does not delegate to them. The court stated, the provisions governing elections reveal the framers' understanding that powers over the election of federal officers had to be delegated to rather than reserved by the states. This obviously would apply to election of Article 5 delegates as well. Any power to set qualifications for members of the national Congress can't come from reserved powers of state sovereignty, but they have to be delegated powers of national sovereignty, meaning it has to be expressly stated in the U.S. Constitution itself. And in the absence of any constitutional delegates to the states have power to add qualifications to those enumerated in the Constitution. No such power exists. As the case goes on to talk about, Article 1 gives the states power, a little bit of power, but not to set qualifications, only as to Article 1, the Article 1 legislative system. Article 5 provides no such power, and likewise it provides no power to the national government either. The power over the convention is reserved to the people, because that's our theory. And referring right back to original theory, the Supreme Court in the U.S. term limits case goes back to Alexander Hamilton's statement in Federalist Number 59 that nothing can be more evident than that an exclusive power of regulating elections for the national government in the hands of the state legislatures would leave the existence of the Union entirely at their mercy. And so the court talks about basically the right of self-preservation. The U.S. government has the right of self-preservation, which means it has to protect itself from allowing the state legislatures to slowly tear it down if you were to give the state legislatures power over the elections for the national government. And this danger applies even more so for elections for the Article 5 convention, because it's not just legislation. You're talking about the fundamental law of the Constitution itself. And then near the end of the term limits opinion, the Supreme Court connects the concept of popular sovereignty to the fact that the people have the right to vote for whom they wish. The state legislature should not be interfering. The second important term limits case in the modern era is Cook versus Gralike, Gralike, 531 U.S. 510. It's a 2001 Supreme Court case. In there, the court makes very clear that the state legislature's power over elections in the national government are delegated powers through Article 1. There is no such elections clause or qualifications clause in Article 5 that delegates any power to the state legislatures over the Article 5 constitutional amendment elections process, and therefore they would have no such power. The other important point established by the Cook versus Gralike case is that state legislatures have no power to give binding instructions either to the Article 1 legislative branch, and it would apply equally as well to the Article 5 Constitutional Convention. You want your representatives, whether it's in the legislature or at a constitutional convention, to be free and independent people, thinking on their own. You want them to do the best job for all of us. So here's a quick review on our illustration, the Devil's Loop of the American Constitution. We aren't able to start the Constitutional Convention per Article 5 without a ratio of representation, and without the ratio of representation, we can't decide what the form of the convention is. So that is where we should focus our attention. The key to opening the door to the Constitutional Convention is the defect in the Article 5 Constitutional Convention clause itself. You must keep open the people's path to alter government. And if there's a defect in that clause itself, if the people just continue to press the issue, it should open the door. The state legislatures should start voting for the Constitutional Convention with full power. The right of the people to establish and alter their own form of government is stated in the Declaration of Independence itself. This is a review of one of the early slides in this presentation. We're now transitioning into thinking about a model rule for the Article 5 Convention itself. We will look at we will go through a clause-by-clause review on each clause, ask if it's per theory or per compromise. If it's per theory, has there been any defect discovered through time and experience? If it's clause per compromise, we could ask, can we massage this clause out of the Constitution and get back to the theory of free government? And this is also a way for the citizens to discuss who they want to vote for, and for candidates to discuss with citizens what they plan to do if um, if they earn a seat at the Constitutional Convention. Here's a guide for a basic proposed model rule for Article 5 conventions. This is set out in illustrative form. It's a contingency table or contingency matrix. You see in the left two columns, in the column under the heading per theory, if a constitutional provision is per theory and it's working properly, you leave it alone. If people can make the case that the provisions that are per theory have an error or defect in them, and that's been discovered through time and experience, then we should be looking to amend or strengthen those provisions because they're key provisions. Now, if the textual provisions in the Constitution are based upon a compromise of theory, and that compromise still exists, then I suppose you have to keep that clause there. But if a case can be made that the compromise, the reasons for the underlying compromise no longer exists, and we have a way to bring the Constitution back closer to the free theory of to the theory of free government with less compromise, then it will strengthen the system overall. So we have to have a basis for talking about the theory of free government. We have 4 original sources that we look at. The records of the Federal Convention of 1787 in 3 volumes are edited by Max Farrand, freely available over the internet. The Federalist Papers, 85 articles, written by James Madison, Alexander Hamilton, and John Jay. Also freely available over the internet, focus on Federalist number 10 and numbers 39 through 61. Those talk about the essential elements of Republican government. We look at Eliot's Debates, volumes 2 through 4. These hold the readily available records of the state ratification conventions. And then we look at the records of the First Congress and the history of the preparation of the Bill of Rights. By studying those documents, you're able to pull from them the essential elements of a Republican form of government, including that the people are the sovereign, that there should be voluntary consent of the governed to be governed, that governmental powers are limited, the people have the right and power to alter their own form of constitution, and they should have an open and direct path to amend that constitution without interference by the federal government. You should have a check and balance system and a separation of powers. You should have full representation, which means meaningful and robust representation. Federalist number 10 talks about expanding the sphere of representation in order to protect liberty. And Federalist numbers 55 through 58 explain to us what is really meant by a Republican form of representation. Federalist numbers 55 through 58 relate back to Federalist number 10 and the concept that you should be augmenting representation in order that representatives have knowledge of their voters' circumstances, they think like they're voters, they feel like they're voters, and you don't want to have a situation where it's so unbiased in favor of the wealthy in the legislature that they have biases against the poorer parts of the electorate. Other essential elements of a Republican form of government include the rule of law, meaning that all persons are equal under the law and that there is a consistent application of the law. That's the definition of justice. You want your citizens to have a veneration for the rule of law, meaning that the citizens think it's a good thing to follow the law. You want your representatives to be virtuous, meaning that they have the ability to set their own personal interests aside and to work for the common good. You need your government to have energy, vigor, and dispatch, especially for things like national defense and quelling any kind of internal unrest. And as a type of backstop analysis, we look to make sure we do not have hereditary government and, of course, no dictatorships. Elections in a Republican form of government must have certain characteristics. Free elections, meaning by the people in an equal one person, one vote standard. fair elections, meaning procedures to protect that standard, full elections, meaning all citizens have the right to vote and to an equal vote, and frequent elections, meaning you want a chance to replace bad representatives on a frequent basis. So what do we need to begin the Article 5 Convention? First of all, rules of suffrage, a system of representation. In this illustration, the twin pillars of representation, we can start thinking about how we protect our own liberties. In the Article 1 legislative system, you want a solid system of representation or the pillar becomes weak. In the Article 5 amendment system, likewise, you need to have just as solid a representation system, which means robust representation, enough representatives to cover the entire population. George Mason, at Constitutional Convention, makes clear that at least one part of the government has to be actuated by elections by the people. Making sure that there are elections by the people for the Article 5 Convention Clause relates back to James Madison's concept in Federalist No. 10 of extending the sphere of representation. And in order to protect the entire system, that extension of the sphere of representation must be applied to both pillars of representation, both for the legislative system and for the amending system. And remember, the Article 5 Convention Clause begins with a one state, one vote process to call the convention. It ends with a one state, one vote process to ratify a proposed amendment. Therefore, the convention itself must be a convention of the people based on democratic principles. It's important for the people to protect their rights of suffrage in the amendment system. Here are three ways that anti-democratic actors may try to shrink the sphere of representation. They may try to disqualify voters in some manner. For example, at the beginning of our nation, they had property ownership qualifications. Another way is to disqualify candidates. Property ownership qualifications are one of those. Having a system where there's so few representatives that the cost of winning an election is so high, it's not even reasonable to think that ordinary workers would have a chance of having any real representation in the system. Another thing to disqualify candidates is to say that they have to support a certain proposal or slate of proposals. Another way is to limit the number of candidates, in other words, keep them small. James Madison, August 10, 1787, at convention stated, "A republic may be converted into an aristocracy or oligarchy as well by limiting the number capable of being elected." Over the course of our history, the ratio of representation in the legislative branch has shrank. In this right-hand column, it says ratio of representation. The ratio is 1 over this number. Initially, with a smaller population, you had better coverage, but as time goes on, you get more and more of a disconnect between the ordinary citizen and their government. The nation reached 435 representatives in the House in 1910, when the ratio was 1 representative per 210,000 citizens. In 1920, they failed to do any sort of redistricting, and since then, everybody's forgot about the fact that you're supposed to augment representation. That's specifically referenced in Federalist Numbers 55, 56, and 58. It's dropped out of the system. The citizens haven't demanded it, and so you've got a ratio of representation that's starting to move towards 1 million per representative. That's no way consistent with the definition of a true Republican form of government, where all citizens should have somebody in Congress that thinks like them and knows their circumstances. So here's an interesting way to teach this lesson, hopefully that people will remember it. 1920 was the year that the ladies made a deal with the devil to obtain the right to vote. The 19th Amendment gave women the right to vote in 1920. That same year, 3 other things dropped out of the system. Going back into history, first of all, even though Congress has power over rules of election in the national system, they did not pass any uniform rules up until 1842. Then in 1842, they started to pass some anti-gerrymandering legislation that basically said that there had to be districts composed of contiguous territory. In 1870, Congress began requiring these districts to contain approximately equal numbers. By 1911, the customary legislative provisions required compact districts of contiguous territory and equal populations. In 1920, when the 19th Amendment was ratified, Congress completely failed its duty to reapportion. Despite a doubling of the voting population, no new law was passed that year, and no new representatives have been added to the House since then. After the 1930 census, the requirement of compact districts of contiguous territory and equal populations was no longer part of ordinary national legislation. So we went through a period of what was called silent gerrymandering. It was basically a malapportionment, and that was the rule until the 1960s one person, one vote cases. Here's another way to look at what happened in 1920. It was like trading chess pieces of representation. If you assign the women's right to vote as being your queen, having 9 points, and then not augmenting or adding representatives to Congress, call that silent malrepresentation, assign that 5 points, because that's a huge part of our system. That would be a rook. Assign the fact that they are no longer, or that they were that Congress was allowing malapportionment in unequal districts. Assign that 3 points for a bishop, and assign a knight 3 points for the gerrymandering that was going on, the manipulation of the districts. So you traded 9 points for 11 points. It was a win for the women, but a loss for long-term representation. This is what we do know about an Article 5 convention. There will be elections by the people for the special purpose of amendment. Those elections will be on a one-person, one-vote basis, and the Article 5 convention will have full power within its sphere, which means deliberation and official proposal of amendments, but those won't become part of the Constitution. They're just proposals and subject to ratification per Article 5. The 1963 case of Gray versus Sanders provides us the rule for how the elections would work for the Article 5 convention. Everybody would have to have an equal vote, more or less. An interesting point to be made here is that the people are actually not limited to the state lines. You could actually do something different, though I strongly suggest people do not think along those lines, that we probably should just stick with what we have, but extending the sphere of representation, as we show a little bit later in this presentation, will probably be the best way to address this. There is only one ratio of representation stated in the U.S. Constitution, 30,000 people per representative, and that can act as a tiebreaker if the nation can't agree. What we don't know about the Article 5 convention is the ratio of representation, how many people are going to go, and we don't know what the form of convention is, because you first really need to know how many people are going before you decide the form. But what's interesting is that it's the people's power. And so there is no floor to the ratio of representation in Article 5, like in Article 1, which requires that you have at least 30,000 inhabitants per representative. It's also important or interesting to note that the average ratio of representation for the state ratification conventions was 2,376 compared to the 30,000 number set forth in Article 1 of the U.S. Constitution. Another interesting point is that the 30,000 figure in the U.S. Constitution was set at a time when they actually expected that the federal government was going to stay in its sphere, but in the 1930s and 1940s, the U.S. Supreme Court opened up the powers of the United States government by establishing what is called the Dormant Commerce Clause. They basically reinterpreted the Constitution in such a way which greatly expanded federal powers, so that now the fingers of the federal government reached into local matters. And that was one of the arguments about why you didn't need more representatives. Well, now that the U.S. Constitution does reach into local matters, you need more representatives in order to protect people's local interests. With respect to the form of the convention, note that there's no requirement that you start in one location. So we can start in the districts rather than in a single location. And this addresses what is an unproven concern that too many representatives in one location might cause chaos. This, in my opinion, is how we should proceed based upon the text of the Constitution and based upon everything we know about the theory of free government from studying the original record. We will want to start our Article 5 convention with a ratio of representation at about 30,000, the only ratio of representation set forth in the text of the Constitution. Those people would initially meet in the existing 435 congressional districts, with 30 delegates in each district. You'd have elections by the people in 30 sub-districts. You could call these the constitutional enclaves, the concept being that they are protecting our constitutional rights, and they would have full power to do a clause-by-clause review and propose such amendments as are prudent. Rather than waiting for 34 state legislatures to vote for the same sort of Article 5 convention and then challenge that, there's a much more aggressive path. We can start attacking state legislation that seeks to usurp the people's rights over the Article 5 convention. So some easy targets are in Florida, Georgia, Indiana, and North Dakota. Other state legislation which can be attacked because it is unconstitutional is legislation in Tennessee, Texas, Utah, and Wisconsin, especially the Texas government code, which declares that only members of the Texas House or Senate may be delegates to the U.S. Article 5 convention, thereby shutting out everybody else in their state from a chance of even going. The best option would be to urge our state legislators to vote for a resolution for the full-powered Article 5 convention, without limits to topic, time, or otherwise, everybody understanding that these are just proposals that are still going to come back through the states for ratification. Absent that, start challenging state laws, as I've just talked about in the prior slide. Another thing is to challenge the limited power Article 5 applications themselves. They're not proper applications. Another thing is to challenge any state supermajority requirements for the Article 5 applications or amendment ratifications themselves. The best solution may be at the national level because Congress still has the power to propose constitutional amendments. So if we can find one representative or one senator to start the process, we might be successful. The new amendment would allow the people to vote for their own Article 5 constitutional convention. If no such convention had occurred in the past 50 years, you would have a vote at every presidential election, and if 2/3 of the citizens vote in favor of the Article 5 convention, then it will commence. If you are supportive of the Article 5 convention of the people, or if you just want to learn more, please get a copy of my book. It'll save you much time in your studies.